Welcome to the 2020 Virtual Civil False Claims Act and Key Time Enforcement Institute, sponsored by the ABA Criminal Justice Section. This session is entitled Litigation Issues. Before I introduce our panel, I would like to take a moment to thank our sponsors. Cone, and Calipino LLP is a supporting sponsor for the 2020 Virtual Civil False Claims Act and Key Time Enforcement Institute. Thank you for your support. Moderating this session is Patrick Klein. Patrick serves as Senior Trial Counsel with the Department of Justice in the Civil Fraud Section. Patrick, you may proceed with the program.
Thanks very much, Donna. And as ever, it is always weird to see your picture up on a PowerPoint presentation. My name is Patrick Klein. I am, as Donna said, a Senior Trial Counsel in the Fraud Section of the Department of Justice. And I'll be moderating this panel. And we are very fortunate to have a really good panel today that represents a variety of different perspectives on the False Claims Act. We've got Greg David, who is an Assistant U.S. Attorney and also the Civil Chief in the Eastern District of Pennsylvania. We've got Steve McCallister, who is the Special Deputy Attorney General and Civil Section Chief in the Medicaid Investigations Division in the AG's Office for the North Carolina Department of Justice. We have Dan Miller, who is a partner at Walden, Macht, and Haran. And we do not have Doug Baruch, although we may get him at some point. We are having connection problems. It's 2020. So hopefully we'll get him on as well to provide perspective from the defense bar. So let's jump in. We, as I think most of us certainly on the panel and the presentation know, it's impossible to cover litigation issues completely in 1 hour. And so that will not be our task today. We have selected a few topics that we think are of an interest and will generate some good discussion. And so we'll try to get through those at least in the course of the hour today. We will be, please ask questions throughout the presentation. We'll be monitoring the questions and throwing them out to the panel as we get them. So please don't be bashful about doing that. And finally, although it's noted in small print on the PowerPoint, the views expressed in this presentation do not necessarily reflect the views of the Eastern District U.S. Attorney's Office for Pennsylvania, Department of Justice, whether federal or North Carolina. So with that out of the way, Donna, if you could turn to the next page, let's dive into the topics we've got today. So we've selected 8 topics for discussion, and we're going to go through them in turn. And the first topic is the role of a relator in intervened cases. Donna, you can go forward, then go forward again. So the role of the relator in an intervened case. When a government intervenes, it has the primary responsibility for prosecuting the action, but what role does the relator have in that intervened case? And let's start with Greg David. Greg, your office has spent years investigating the case. You make the decision to intervene. What role should or should not a relator have going forward?
Thanks, Patrick, and good afternoon, everybody. I scrolled down the list of people who are attending. I see many friends, many colleagues, many former colleagues, so I appreciate you being here, and good afternoon. I think as you can see from the statutory quote in the slide, the Relator's Counsel, the relator has a right to continue as a party to the action. So I think you'll find a consistent view among the U.S. Attorney's offices and civil fraud's main justice that their participation is appropriate. The extent of the role of Relator's Counsel is going to depend on a lot of things, what kind of case it is, who the government attorneys are, who are assigned, a whole number of things. So I think what's typical in the vast majority of cases, you're going to expect to see the government take lead where the government has intervened on all the claims, right? The Relator's Counsel will still be participating and can serve discovery, for example, but you'll want to see the government's attorneys and the Relator's Counsel coordinating on discovery to avoid duplicating effort or imposing an undue burden or anything like that. And if it's a big document case, I think it would be typical for the government to seek Relator's Counsel's help in making sense of that large body of documents. That's the typical scenario, but I think certainly you'll see instances at either end of the spectrum. So the far ends of the spectrum are no involvement from Relator's counsel, or deep involvement and operating shoulder to shoulder with the government. So I think that's the picture.
And Dan Miller, as Relator's counsel, what is your perspective on the role of you and your client when the government intervenes in a lawsuit?
Well, I mean, as most folks would agree, I think you're very pleased to see that happen, because then you have the full power and weight of the government involved. So the defendants tend to take much more notice of the case as opposed to a decline one. Largely, I would agree with what Greg just said. Relator's counsel, well, I guess it depends on the Relator's counsel, but in terms of our practice and what resources you have available to you, we tend to try and provide as much support as the government is willing to accept. So we'll offer, as Greg was intimating there, we will offer to review documents regardless of how large the productions are. We have access to and both proprietary document review platforms and some of the more commercially available ones, and we're pretty facile with those, including the new technology that permits you to do intelligent searching rather than just Boolean searching, and so that's a big thing, I think, to offer to the government in an intervene case. And sometimes we get involved in assisting with briefing. There'll be discrete issues that the government may want us to look at, but by and large, the government takes the lead on that stuff because they want to make sure that their articulation of the law is consistent with DOJ. So yeah, those are just my off the cuff initial thoughts about the role of a relator in an intervene case.
Dan, would there ever be a situation where in an intervene case, relator would be conducting discovery on its own, as it's submitting its own request for production, for example, something like that?
Yes, I think it's permissible, as Greg was just suggesting, although I have not personally found myself doing that, because normally it just kind of causes difficulty, because you might be, if you do that, might be asking for or taking positions that are inconsistent with those being taken by the government. So normally we will take a back seat to the government in discovery, other than to serve as sort of advisory counsel and putting potential discovery together. That's how we view, at least in my practice, that's how I view our role. I suppose hypothetically, if the government was, we think, undershooting what is necessary to prove to meet the case in chief, then we might issue our own discovery. But typically, the government lawyers are very competent and we wouldn't be in that position. And in fact, I've never been in that position. So yeah, that's what I think about that.
I am told that Doug Baruch has joined us. Doug, are you there?
I'm here. I can see you. I don't know whether you can see me.
Well, great. So we're happy to have Doug Baruch with us, a partner at Morgan, Lewis and Bockius. And Doug, before I bring you into the discussion about the role of the relator in an intervene case, I think at this point it's appropriate to note that if you've practiced in the FCA space for any appreciable amount of time, and certainly if you've attended this conference in the past, you know the name of Jack Basie. And with his passing last week, I know Doug is his former partner and friend. You wanted to offer some thoughts about Jack, and so I think we'd all welcome that at this point.
Well, Patrick, I really, really appreciate that, and I'm sorry for the technical difficulties here. It's most unfortunate. But let me please take just a few minutes, Patrick, if you don't mind.
Of course.
Just sharing some remarks about Jack. I spoke with Rick Morgan a few days ago, and we thought it would be appropriate for me to talk about Jack here. Jack's passing a week ago today on Thanksgiving morning is really a tremendous blow. For as long as I can remember, Jack's been this irresistible force in my life. And that's a sentiment that I've heard constantly over the last week since people learned that Jack was gone. Jack was larger than life itself, so it's simply unfathomable that to accept that his own life could be extinguished at all, let alone so suddenly. Many of you know Jack for his False Claims Act work. In fact, Jack unquestionably is the dean of the False Claims Act defense bar, and I don't think it's too much of a stretch to suggest that he was the dean of the entire False Claims Act bar. One of Jack's proudest accomplishments is his treatise on the False Claims Act. I'm sure many of you at government offices or firms have that at your desks. Jack was sure to be objective in his recitation of the law, but his opinions on what the law should be came through on almost every single page. And I'm glad that Jack's made arrangements to keep the book going even after his so-called retirement. And of course, in recognition of his stature and respect in the False Claims Act world, Jack was a fixture at this conference for years. He was teaching the fundamentals. He was overseeing the panels. He was chiming in with his thoughts whenever he thought it would spice things up a little bit. And Jack used to introduce himself, for those of you old enough to remember, at this conference and some others in rather unique fashion. After recognizing the other participants, he'd often close the introductions by saying, "And I'm Jack Basie. And if you don't know who I am, you don't belong here." On other occasions, Jack would help pronounce his name by saying, "I'm Jack Basie, rhymes with crazy." Despite being a vigorous advocate for his clients and really a passionate spokesman for all the excesses and overreach that the False Claims Act brings with it, I can safely say that Jack has had as many, if not more, friends on the Justice Department side and the Relator's bar side of the equation than he did on the defense bar side. And maybe that came from his the early part of his career when he was a DOJ trial attorney, and those were some of his proudest moments in life. He forged many, many enduring relationships and friendships there. He was well respected by all, which is a pretty remarkable feat these days. And what made Jack so well respected and well liked was his joy and passion for legal work, and also his ability to get along with friends and adversaries alike. Jack knew his stuff, but it's funny that he often had trouble with some of the minor details. He sometimes, and maybe some of you personally experienced this, Jack regularly mangled people's names. And he sometimes mangled the names of cases. And sometimes he mangled, awkwardly, client names. And sometimes he even mangled judges' names when he was arguing in front of them. And Jack also had a problem with lists. More often than not, when Jack was making several points in favor of his position, he'd start off with point A and then move on to point 2. Not a lot of consistency there, but we put all of that aside because Jack knew the material inside and out. He was a strategic thinker. He always added value, and he was never ever afraid to give candid, no holds barred advice to clients, and that advice was spot on. And Jack and I were law partners for many years, and I'm going to remain his co-author, but Jack also was my mentor and my close friend. And I was thinking over the past week about how lucky I was to have had Jack in my life and how close I was to missing that opportunity altogether. I met Jack on my first day as a summer associate. That's when I had the fortune or misfortune, some would say, of receiving my first summer associate assignment. And that was to report to Jack's office because he had an urgent project. And why anyone would assign a first day summer associate to handle an urgent project, I have no idea. I'll never know. But I made my way to his office as I was ordered to do. And as a lot of you have experienced, I heard Jack long before I actually laid eyes on him. In fact, I think I heard Jack while I was still in the elevator. That's because Jack tended to be a little loud and a little exuberant. Nothing in law school had prepared me for someone like Jack. Nothing in my entire life until then had prepared me for someone like Jack. And I've long since forgotten the details of what that actual summer associate assignment was. But what I remember vividly was how excited Jack was about the issue and how convinced he was that he was right, and that only a fool could fail to get him the case law to back up his theory. Enter Doug Baruch, summer associate, day one. So I came pretty close to going off in a different direction with my career. All of it could have ended right there 30 years ago. I never found the case that Jack was looking for, and that was a problem that repeated itself over over many years. Um, and I had serious doubts about, after that first assignment, as to whether I was really cut out for this law thing. But Jack was gracious. He was patient. He was supportive. He was polite, and I stuck with it. I came back to the firm. I asked to work with Jack and the firm's newborn False Claims Act practice group that was getting established in the aftermath of the 86 amendments, and then we were off to the races from there. We made new False Claims Act law. We raised constitutional challenges, some of which remain undecided today, and we traveled the country together. All the while, Jack was Jack, as wise and practical and blunt as ever, and as loud and exuberant and animated as ever. In meetings, I'd learned to sit a seat or two away from Jack because he had this tendency to wave his arms when he talked, which often led him to swat his coffee cup, spilling coffee on nice conference room tables around the country, sometimes on his neighbors, sometimes on his friends, sometimes on his clients. He's shorted out a bunch of conference room table microphones over the years. But Jack, he loved it. He enjoyed life to the fullest. I'm guessing that some of Jack's volume came from his upbringing. As some of you may know, Jack grew up in South St. Louis, where his father ran a bowling alley. So just think about how loud Jack had to be in order to, just to be heard. Remarkably, Jack's writing was loud. For those of you who received emails from him, you know that he always used bold font. And when he was really animated, you know it because he used both bold font and all caps. So I learned a lot from Jack about how to be a better lawyer and a better person. And Jack's passions extended well beyond his client matters. For a long period, Jack was one of the managing partners in the Washington office of his firm. He hated every minute that he had to spend dealing with the nonsense about partner comp and that sort of stuff. What he loved was being there for the non-legal staff, and they loved him back. He knew everyone's names, even if he sometimes garbled them. He knew their spouses' names. He knew their kids' names. He delivered presents on holidays. He mourned with them when they suffered a loss. He comforted them when they were struggling. He was someone everyone could and did relate to. Jack retired several years ago. He had talked about it before then for several years, and he's talked about it ever since. Recently, he'd taken to telling clients that they shouldn't schedule any calls with him after 5:30 because he'd probably be on his second beer by then. And he'd tell clients what his tea time was so that they wouldn't interrupt him on the golf course. And on recent calls during COVID, even early last week, you'd often hear Jack's dog in the background and his grandkids in the background, since he never put his phone on mute throughout the entire call. But the real reason Jack stepped back a little from the practice of law is so that he could spend more time with his family and he could travel the world. He was a true family man, loved his wife, loved his kids, loved his grandkids, most of whom inherited his loud gene, by the way. But as I hope you can tell, Jack was a special person in many ways. His passing leaves a void in our professional and personal worlds that's going to be hard to fill, and he leaves a void in the False Claims Act world, which will never be completely filled. So I hope all of you can latch on to a memory of Jack and carry that with you in the days to come. And thanks, Patrick, for indulging me there.
Patrick, I think you're muted.
Thank you. I knew I was going to do that at least once. Donna, if you could move forward to the next topic, which is the role of the government in declined cases. You can go forward one more, please. And so this is the flip side of our previous topic. In this case, the government has spent time investigating and has decided, for whatever reason, to decline intervention in the case. And we see on the slide here some things to consider from the government perspective about what may or may not happen in declined cases. But Greg, let's start with you. What are your thoughts about the role of the government in a case that you or your office has investigated and ultimately declined?
Sure. So I think there's a few different places where the government is going to get involved in a declined case. We are always striving to actively monitor our declined cases. And one of the things that we're going to be thinking about is whether or not to file a statement of interest at certain key junctures. We always like to hear from Relators Counsel or Defense Counsel. One, do you think there's an issue that's appropriate for the government to lodge a statement of interest? And two, to hear their views on what position the government ought to take. We always invite that conversation. Separate from statements of interest, we're thinking about, should we jump back in this case? And per the statute, we can intervene for good cause shown after the declination decision. So it's not uncommon for Relators Counsel, and we invite this, to bring information to the government's attention if there's been a major development or a material change in the understanding of the case or a new potential cause of action. On the flip side of that, sometimes we might be thinking about whether or not we should move to dismiss the case after the declination decision. And since Michael Granson's memo, we've certainly seen an uptick in requests from defense counsel to dismiss cases, usually on the basis that they purportedly lack merit. So while we may ultimately disagree with that, we're not likely to turn down the opportunity to have a conversation. We'll want to hear defense counsel out. We're also going to invite Relators Counsel to provide their perspective on that issue. I think the bottom line there, though, is that we view our C2A power as a power to be used sparingly, and I think that's what we've seen in the last few years since that memo has come out. Another area where we could potentially play a role is in discovery. Since even though we're the real party in interest, if we've declined, we're not a party to the litigation, and so you can't just serve a subpoena on the government that's governed by DOJ's so-called TUI regs, and that's something that we deal with, and we deal with often. Certainly, post Escobar in particular, there often is discovery directed towards the government and the officials responsible for making the payment decision, and we're going to be actively involved in that, obviously. And the last area is settlement. Ultimately, even in a declined case, per the statute, you're going to need the government's consent to dismiss the case, and it's also typical that the defendant will want a release from the government for the covered conduct. I think civil frauds practice, probably the typical practice around the country at different U.S. attorneys' offices, is not to be substantively involved in the settlement discussions in a declined case. Typically, DOJ will be approached after there is an agreement in principle between defense counsel and Relators Counsel. Having said that, the practice may differ depending on the U.S. attorney's office that you're dealing with. In our district, it's not uncommon that our magistrate judges who are involved in the settlement process potentially will want our office involved. And if a magistrate judge asks us to be involved in the settlement negotiations, we'll do that. I actually see people on the participant list where that's exactly the scenario as it's played out and it's happening right now. So I think those are the main areas that we typically are involved in a declined case.
And Steve McCallister, on the state side, what considerations impact the states when the government declines a case?
Yeah, I think everything that Greg covered are the same issues that we consider as well. I'll start with the last subject he addressed, which was settlement, and the sort of balance to strike, obviously, in a decline case is that the government's declined. So the nature of the engagement involvement is less, obviously, than if they had intervened. But when it comes to settlement discussions, we found that often there's an opportunity for the states to be involved in sort of shaping those discussions. And, ultimately, if what you need to get is states signing on to a settlement agreement or, dismissing a case with prejudice, you don't want to be in a position where Relators Counsel and defense sort of show up at your doorstep and say, hey, guys, we've settled the case. You have to say, hold on, let's take a look at this, and there might be issues that arise. And so I've found that it's helpful to have an appropriate level of engagement, and that obviously is going to differ from case to case. But earlier on in the settlement discussions, and from the state perspective, the states can, I think, add value to that process. So that's sort of one area where we've had certainly some recent experience. The other thing that Greg touched on was discovery, and with the states, there are a lot of us, and especially in a big global multi-state qui tam. And one of the things that the states can do in the decline context is sort of point the relator in the right direction for how to do a number of things to include obtaining data. So often, at least in the Medicaid world, these are data-intensive, data-centric cases, and it's helpful for the states to coordinate with their Medicaid agencies and sort of prep them for the fact that the requests are going to be coming for data, and let the relator know, here's who you can direct those requests to, and as an informal manner, here's who you need to talk to at the agency to sort of prepare them for this sort of request. So, that's another role that that we've seen state involvement in. Finally, statements of interest. That's something else that the states have had a hand in. That issue can present either, if relator comes asking if we'll join in, or if we see something that gets filed and we say we have to take a position on this because the way the issue is being presented to the court by either relator or by defense is not consistent with the government's views. So, those are different ways the states have been involved. But again, it depends on the case, and it depends on the circumstances.
Dan Miller, as Relators Counsel, your clients brought a case to you. You brought it to the government. The government investigated and declined. As you bring that case forward, what do you like to see from the government, and how do you sort of interact with the government going forward?
Mostly what I would add to what has already been stated is timing. A lot of times when something may occur in litigation that could potentially trigger the government's interest in filing a statement of interest, there's not much time, and the government doesn't. I don't think I'm being critical when I say the government doesn't necessarily move very fast. There's varying levels of approval that need to be obtained before a statement of interest or the like can be, or for example, an opposition to a public disclosure challenge for post March 23rd, 2010 conduct. It takes a while. So when we see something either in a motion to dismiss or in some other filing, a summary judgment or somewhere in between that we think the government might have an interest in, we try and take a quick action, get the briefing that we think the government could potentially respond to the relevant government parties, and make our pitch for why we think it's a good idea for the government to assert its interest in having the law interpreted correctly. But I would say that timing issue is even more important in actual discovery. The TUI request situation and what's necessary to actually get either data or a witness from the government is time intensive and difficult, and it's different for different agencies, and even when you've done it before, it can take months. So depending on how the scheduling order in the case and what sort of time pressure you're on, we try and think about the discovery we need to issue to the government very early in the discovery period so that we can start that engine up and as Steve was just saying, we do exactly what he just said, which is we try and locate on a practical level, who do we need to talk to? A name, what person at lawyers at CMS do we need to speak with to make sure that this process goes without a hitch, or at least as fast as it can? Because if you issue something that's has a technical deficiency and you don't do your homework ahead of time, then CMS can wind up, if they want to, objecting or saying that your request or your subpoena is technically deficient, and then you start back at square one, and meanwhile 45 days have passed. So we haven't had that happen. I've heard it happening to other people, and I think part of the reason that we haven't had that happen is because we will reach out to the AUSA on the case, make sure that they understand that we're looking to get information from the government, ask them to participate if they would like, or steer us in the direction of the right person. And same for the states. We're doing that right now in 2 cases we're litigating that involve state participants, the Medicaid agencies, and we've gotten nice reactions from the folks on the state level, connecting us to the people at the agency that we need to talk to.
Well, let's move on to the next topic. Don, if you could move ahead, please. So, litigating a case with a mix of declined and intervened claims, this may represent a small percent of the FCA cases that go forward, but they do present some interesting possibilities. Donna, if you could move forward one more. And so, Greg, let's start with you. How does litigating such a case impact sort of your planning, both for discovery and trial?
Yeah, so this is a case that I think historically has come up more rarely, but I think we're going to see that False Claims Act litigation, it's already on the rise. I think that's a trend that will continue. And so you're going to see with greater frequency these permutations. So this permutation is the United States has intervened on some, but not all, and the relator is going forward. There's some other permutations where the states would be involved, and they might be going forward on claims that the federal government is not. But in this scenario, the government is going to typically take lead on what it's intervened in, and the relator is going to be responsible for moving the entire case, including discovery for the decline piece. And probably the best example of this functioning well that I'm aware of is the Halifax case out of the Middle District of Florida. That one settled for $85 million in 2014. The government had intervened on start claims on physician compensation in exchange for referrals, and the relator had pursued medical necessity. Pre-litigation, the court had not given the government as much time as it needed to figure out the medical necessity piece, and so essentially it just didn't come to an intervention decision. Very heavily litigated case, over 700 docket entries, Relators Counsel and the government shoulder to shoulder pursuing these 2 different buckets, and it settled right before trial. So, that's an example of how it could play out and how it could function well, and I think we're going to see more of these permutations going forward.
And Dan Miller, on Relator's side, how does litigating a case with a mix of declined and intervened claims impact your practice?
I've only had that situation happen once, and it was a happy situation in the sense that the AUSA involved liked the claim, but just had plenty to intervene on, and we just didn't want to let go of anything that might bring some potential value. So there were no real issues as the case went forward. We took the lead, as Greg indicated, in our claims. The government took the lead in their claims. We collaborated across, spoke to each other and coordinated in terms of, making sure we didn't set the defendant up to be able to argue that they were being treated unfairly by 2, separate teams of, for lack of a better term, prosecutors. And it went well, but I can imagine that there is a situation perhaps where it might not go well, either because the defendant is able to successfully, persuade the court that this amounts to, some form of, inappropriate pursuit of claims. I think there's actually a case that came out last year where the relator's claims were dismissed on the grounds that the relator didn't have the authority to move forward with non-intervened claims, even though the government was going forward, and even though the claims hadn't been dismissed. So there's not much law out there on what the rights of the parties are, other than what's in the act, and then a couple of stray cases. And it's kind of a rare situation, but as long as you're getting along with your AUSA and coordinating, you're probably okay. And that's been my experience.
Thanks, Dan. Donna, let's move forward to the next topic, which I just have to say is Escobar, and that conjures up all sorts of images. But and I know that on in this seminar, I know there was a topic on Escobar, I think, and we're not going to get into the sort of the nitty-gritty of the decision itself. So please don't turn this presentation off. We're actually going to focus more on the practical aspects of how Escobar impacts litigation and discovery and those types of things. And so, Doug Baruch, from the sort of defense perspective, how has Escobar impacted FCA litigation?
Yeah, so it's changed it. It's made it's opened the door to discovery and opportunities, discovery against the government that wasn't necessarily available before, and opportunities to pursue early dismissals and on the grounds of lack of materiality. So, we have in the decision itself some very clear signals that materiality is supposed to be taken is a rigorous and demanding standard, and that there are opportunities early on for a trial court to get involved and enforce that particular provision. So, in terms of discovery, we try to focus early on getting the discovery that we need, and in particular, we look for discovery into the way the agency has treated claims, not just of ours, but of similarly situated companies who are presenting claims to the same agency. And that's an area where oftentimes we start to butt heads with the agencies and sometimes the government attorneys, because it's difficult for agencies to let go of that sort of information, particularly if it involves competitors and things like that. But it's important to press for that information early and often in these cases, because it's really it can be a gold mine in terms of establishing that the particular practice at issue in your case is not one that was treated similarly by the agency in other cases.
And Greg, over to you. I guess I was going to phrase my question, why is everything that Doug just said incorrect? But if you could give us your perspective on how the government views Escobar and how that impacts the discovery that is taking place.
There are plenty of cases where materiality is actually not going to be in play. So I think, as most folks know, you have cases where there's a joint delegation with civil frauds at Maine DOJ and the U.S. Attorney's Office. But there are other cases where essentially it's been delegated to the U.S. Attorney's Office. And in that latter bucket, you could have a materiality fight, but I think it's less likely on the whole. You can imagine sort of the case where, it's sort of like a DME kickback scheme. It's a recalcitrant defendant who would engage in pre-litigation discovery, wouldn't engage in pre-litigation resolution discussions, and so litigation became necessary. But when it is in play, you should know that on the DOJ side, we will have thought through these issues pre-litigation. We will have had substantial meetings with the key agency officials and decision makers vis-a-vis payment and all the key Escobar questions. We're going to believe that we can satisfy Escobar and materiality and have dotted our I's and crossed our T's prior to filing suit. And so we'll thought through these issues and be prepared. And hopefully, if we've done our job correctly, there shouldn't be any surprises on that front.
And Doug, in the interest of fairness, I'll give you a chance to respond to that.
Yeah, and I appreciate that, and we understand that the DOJ attorneys and U.S. attorneys have that obligation, particularly when they're intervening. But they don't intervene in every case, and so it's the same type of rigor isn't applied necessarily to claims brought by a relator that are in a declined case. And so that type of discovery is even more important in a declined case, in my view.
Steve McCallister, walk us through how Escobar impacts the states in False Claims Act cases.
I would echo Greg's sentiments, and I would, suggest that the issue of materiality is something that informs our approach to a case at the investigative stage. And so, if we find ourselves intervening in a case, we've looked carefully at the materiality issue, and we believe we have, substantial evidence of materiality. I also agree that it's not always an issue in a case. A kickback case, for example. Now, there might be cases where, you have a regulatory violation or something like that, where, the issue of materiality maybe is a bit more present. But, at least my view is, even sort of post-Escobar, the sort of cases we get involved in are cases where the nature of the falsity at issue is important, right? It's important to the case. So, I don't know as a practical matter that it has a meaningful impact on the sorts of cases that we get involved in. But I can say it is something we're very mindful of, and I do think it lends the opportunity for defense counsel to engage in broader discovery than they would have pre-Escobar. In particular, to look at the broader landscape of how the agency treat others in similarly situated situations. So, that's certainly something we have to be mindful of as well. And it just, it requires early and thorough engagement with the state agency to sort of work through some of these issues, both at the investigative stage and then if you're litigating, certainly at the litigation stage as well and during discovery.
And Dan Miller, I know you're not scheduled on this topic, but I do have a question about, from the relator's perspective, especially in a declined case, how does Escobar shape the type of discovery that you're trying to get in order to prove your case?
Escobar is huge in most declined cases, even as Steve suggested, where it shouldn't be, like in a kickback case where materiality is determined as a matter of law. Every case that I've litigated since Escobar has included materiality challenges, including kickback cases. So we regard it as really important. And we try, and get as much information from the government as we can during the investigation and prior to the declination, because obviously if there's a problem in there relating to materiality, and it's not a kickback case or another type of case where you can argue that the violation is material as a matter of law, such as medical necessity or something like that. We want to know what the agency's position is, and then many of the folks that are both government lawyers and relators counsel that are on listening in here probably, I think, would agree that it's not the government doesn't often come out and state exactly what the agency's position is on the conduct in question. You may have to do some reading of the tea leaves as you're talking to government counsel regarding whether they are signaling to you in phone conversations that occur pre-declination that there's a materiality problem. So when we have a case like that, we tend to try, just like with regard to getting document discovery or data from the government, it takes a long time. Well, for a different reason, we try and issue the discovery we think may be needed in a declined case relating to materiality almost immediately, because it can drive the whole case. In other words, if you issue discovery to the government so that you can try and get them to take a formal position or some testimony or what have you, which is going to either establish or defeat materiality, you might as well do it up front and find out right away before you go and spend hundreds of thousands or millions of dollars, in huge document productions and deposing a boatload of fact witnesses, only to find out that, you're going to have a major materiality problem. But on the other hand, we're nervous about issuing discovery to the government, even when there is a materiality issue, because what happens if that triggers the defendant to then issue discovery to the government and take the position that, every communication dating to the beginning of time that relates to the underlying conduct within CMS or a state agency is relevant. That we get worried that I think about this all the time. Is it worth it issuing this discovery if we have a pretty good idea? Because if we do issue the discovery, it could trigger a dismissal because the government is going to get a subpoena from us. They're going to get a subpoena from defense counsel. It's a lot of work. The government's already decided that they don't want to pursue the claims. And that presents the flip side of that. What if you don't subpoena a CMS witness to prove materiality? Then how are you going to prove it? Are you going to, get an expert, a former CMS official who may not, is obviously a former official, and they may not have, been there at the time that the conduct was occurring. So you're going to face a potential issue that they don't have relevant knowledge of materiality. So there's a ton of issues related to materiality that Relators Counsel in decline cases are struggling with in just about every decline case.
Can I weigh in there just for a second, Pat?
Of course. Go ahead.
And just speaking on behalf of defense lawyers out there, what Dan said makes a lot of sense, but it makes us nervous and gets us a little upset at times, because to say that you need that the relator needs to take discovery to find out whether they have a materiality problem suggests that perhaps the complaint allegation that says that these are material to the government's decision wasn't fully investigated prior to bringing suit. So it's really that work, just as Greg was saying earlier, should be done before the suit is brought, not afterward.
And to Doug's point, I can't speak for all offices, but I know in EDPA, when we reach that point where we're going to decline, hopefully we've been communicating with Relators Counsel to the extent that we're able to. But when we get to that point, we're going to have a conversation, and we're going to share as much as we can about the reasons that we declined. And sometimes it can be tricky on materiality, but hopefully we're able to have a candid conversation if there's a materiality problem and walk Relators Counsel through it so that they can make an informed decision about whether to pursue that case post-declination. So hopefully folks are doing that during that conversation with the Relators Counsel about declination and making sure that we don't run into those scenarios.
Yeah, and just to put a footnote on that, Doug's point's well taken, but think about the sequence here. The relator in just about any case is not going to have firsthand knowledge of materiality, because the firsthand knowledge of materiality is largely in the government's possession, so to speak. So their good faith, a pleading is drawn and filed in good faith based on the reasonable interpretation of the law and what Relators Counsel best believes whether there is materiality here or not, and that belief sometimes is influenced by what the government tells us during while we're having this, I'll call it the declination discussion, when you get that dreaded phone call, we're going to decline and here's why. But and Greg's office, I know EDPA in particular, is usually very transparent and tells us more than some other jurisdictions. But I've definitely had the conversation with AUSAs that are in a declining posture saying, hey, I'm not telling you not to go forward, but I'm telling you that can't really get into what the agency thinks about this case. And, and that leaves you in a bind. You think you have a good faith belief that there's materiality and you can prove it, but you have no inclination really from the government one way or the other whether your belief is accurate. And then if you elect to go forward and your client, I think you're on good grounds to do that as long as you have a good faith belief that your pleading remains accurate. Sometimes these things cannot get resolved until discovery.
We're going to leave that there. We have about 7 minutes left, and there's a couple more topics we'd like to get to. So Donna, if you could ahead a couple of pages. The next couple of slides are just simply further discussion of Escobar and the types of elements that may be at play when having materiality considerations. So Don, if you could move ahead, I think more pages. Donna? All right, well, we'll plow ahead with the next topic. There you go, one more. There we go. So the next topic we've got is scienter, both at the motion to dismiss and summary judgment stages. And if you move ahead one more slide, please. And so there are the familiar definitions of what knowing and knowingly mean. But obviously, scienter has a couple of different considerations when it's an individual versus perhaps a corporate defendant. And Dan, let's start with you. Let's get your thoughts on scienter, both at the motion to dismiss and summary judgment stage, and what that element means at those two stages.
Well, that's a big question.
And you have about a minute.
All right. I'll take the first one because it's easier.
All right.
It's easier. At the motion to dismiss stage, all inferences are going to be taken in favor of the relator, and so or of the the non-moving party. So we take a great deal of time interviewing our client, interviewing witnesses, reviewing any documents that relate to scienter, because it's the primary element that the defendants attack at the motion to dismiss stage, even though under Rule 9b, scienter can be pled with less particularity than the other elements. So it's a focus of ours because we know it's coming. We know of cases, we know the case law that's coming at us too, especially if there's a claim that the regulations are ambiguous. We're going to see Safeco arguments. Now, these days, that Safeco has been running wild in the FCA litigation. There's a really big case out in Illinois, which is confusingly called Safeway. That's now on appeal with regard to this objective, whether a defendant can plead it or can get a dismissal based on something that it didn't even think at the time, but conjured up after the fact. After thinking about it for quite a while. So I know Doug's going to have something to say about that. So, but we spend a lot of time on this. It's the most important part of the pleading, in my view. And
Doug, over to you.
Yeah, sure. So I'll be very, very brief here. But in terms of corporate liability and scienter on behalf of a corporation, we're looking at the complaint to see whether there are sufficient allegations that a particular individual had the requisite knowledge, because we're looking for opportunities to knock it out on a collective knowledge theory, where there's, because under SAIC, the DC Circuit case, you have to have the requisite False Claims Act knowledge reside within at least one of the employees in order for that to be imputed to the corporation. So we're looking for that early on. And then as Dan mentioned, the other thing that we look for very early on is whether there's something ambiguous about the particular statute or regulation or contract provision that's at issue. And that often is the case. And there's a very good, Dan mentioned Safeco was a very good False Claims Act case in the DC Circuit, MWI. And it says essentially there can be no False Claims Act violation where the law or regulation at issue is ambiguous, where the defendant's interpretation of that regulation is reasonable, and the agency in question issued no formal guidance that basically steered the defendant's interpretation and or told the defendant that its interpretation was wrong. So those are some of the things we look for in the complaint early on, to see whether we have a basis on a motion to dismiss to challenge the element of scienter.
Great, thanks. Donna, let's move ahead one. So motions in limine to shape the issues to be tried. If you could skip ahead one more slide. We're just going to breeze right through this one. The three listed there, the relay share, the award of penalties and treble damages. Those are all typical motions in limine that the government or perhaps relator will file, so that the jury does not hear about any of those things, as they aren't really relevant to the decision in the case. We'll leave that there because that's really all there is to say about that. I'd like to move ahead, though, to a much more interesting topic, which is damages methodologies and sampling alternatives. And Donna, if you could skip ahead one more. And so I'd like to start with Greg to get your thoughts on sort of those types of methodologies and perhaps sampling as well.
Sure. So I know we don't have much time, so let me just frame up the issue. What is statistical sampling? Right? We all know that's using a sample of claims to determine something, usually damages, for a larger universe. Why do you do it? Because it would be impractical to do a claim-by-claim review, although some would argue, and certain cases are going to argue that that's wrong. For FCA cases, it's built on the foundation of numerous cases involving Medicaid and Medicare overpayments. That's set forth by statute and regulation, and that sets forth how you use statistics and statistical sampling to show damages. The vast majority of courts have permitted sampling and recognize its validity. Some district courts have rejected a sampling approach given specific facts of a case. The key issue, though, is the sample has to be sufficiently representative of that larger universe, and that's usually what the expert fight is going to be about. Indeed, the variability of the estimate extrapolated from the sample, that's an important factor in the sample's admissibility. The confidence interval matters. Sometimes, setting damages at the lower limit of the confidence interval, that may address the variability issue, but sometimes it won't. We do sampling pre-litigation as part of determining is there any there, a probe sample. It's part of having a resolution discussion. That's going to look different than the sampling that would be done for purposes of litigation. For litigation, it's really got to be buttoned up. Fights in litigation about the admissibility of the sample, that's probably not going to happen until shortly before trial, teed up through a motion to exclude the expert testimony. There's cases out there where people try to get an earlier answer and the courts just kick the can down the road. Let me just pause there and give other folks a chance, as I know we're short on time.
Yeah, Doug, let's get your thoughts on this.
Yeah, and I know we're out of time, and I'm contributed to that earlier on, so I'm sorry for that. But in terms of the statistical sampling, it has not been established, I think, sufficiently in the federal courts yet that sampling over a defendant's objection can be used to establish either FCA liability or damages. Yes, it's been done in the past. Most of the time, there's been no contest about it, but the circuit courts have yet to weigh in definitively on whether it's appropriate to use false sampling to establish False Claims Act liability, particularly because False Claims Act is a statute that focuses on individual claims and proving the elements of individual claims. So I think it's yes, there's been cases and Medicare cases provide some specific support for using sampling, but that's a very limited level of support because the Medicare regulations have particular provisions in them that allow for sampling, and there's contracts involved there. But in the wide range of False Claims Act cases, I think the use of sampling to establish liability in particular is inappropriate, and it has not been upheld at the circuit level in any sufficient level of detail.
And Steve, we'll give you the last word on this topic.
I think sampling has a place, certainly at the investigative stage, and I do think you kind of have a shift when you move from investigative sampling to something that would be a trial sample for either liability or damages. For trial sampling, I think you want to make sure that you're conversant in statistics, that you have a good expert, that you understand how your sample was drawn. But I think the science of statistics is sound, and I think with the appropriate experts and the appropriate methodologies, I think it can be useful to establish not just damages but liability as well. So that's my view.
I want to get to a question before we break, and the question was asked from the audience, and I'll throw this out to the panel. Is there a statutory motivation? I think this goes to the scienter element. Is there a statutory motivation to keep employees and corporate officers in the dark about the terms of a particular contract or regulatory requirements? Throw that to whoever wants to take a shot at that one.
Yeah, let me just start there and say no. I don't think so. I mean, I think most responsible corporations have compliance programs and the like, and it's not in their interest to keep people in the dark about what the appropriate regulations are. That never works to their advantage, especially on a FCA level of scienter standard with that reckless disregard and deliberate ignorance.
Yeah, I
All
completely
right, let's
agree.
leave that there. Donna, let's move to the last topic, and I'll wrap this up. This is trial odds and ends, and if you can go one more. And obviously, if you found yourself in an FCA trial, someone has done something horribly wrong. But those are just a couple of different aspects to think about if you approach an FCA trial. And we'll have to leave those there because we are now over time. That's all the time we have, but I just wanted to thank you all for joining us today. Wanted to thank the panel for a really good, lively discussion. On behalf of the American Bar Association and the ABA Criminal Justice Section, I'm Patrick Klein. Thank you all for joining us. And please join us for our next session that's starting in 15 minutes, which is settling an FCA case. And during the break, you're encouraged to browse the virtual lobby for any networking sessions. Thanks very much.
Thank you.
Take care.